Good morning, ladies and gentlemen. Welcome to the Law Society of Hong Kong's second installment of the 7th Belt and Road Conference. I'm Celeste, a member of the Greater China Legal Affairs Committee. It is my honor to be the MC of today's webinar. Flowing back, the Law Society has been organizing an international Belt and Road Conference annually in Hong Kong to serve as a platform for professional exchanges among legal practitioners since 2017. Thankfully, our 7th Belt and Road Conference was successfully concluded in November 2024 with registration by over 500 participants from various sectors, from 32 jurisdictions, including 23 representatives of the Consulates General, honorary consulates, and officially recognized bodies. By popular request, we are glad to gather another 1,300 of you today. Bearing the same theme, legal professionals joining efforts in advancing 8 major steps to build high-quality Belt and Road cooperation. Today's webinar will be an interactive continuation of the previous conference, which aims to expand professional conversation among elite speakers and audiences across various sectors and jurisdictions. Before we begin, we have some important housekeeping reminders for your noting. The webinar is conducted fluently in English and only with no translation or interpretation. In this webinar, you are automatically muted and are in listening mode. The chat room allows you to send chat messages to the hosts, panelists, and attendees. And if you have any questions for the speakers, please feel free to type your questions in your Q&A box during or after the presentations. For more detailed instructions regarding the Zoom webinar functions, please refer to the chat notice posted by the Law Society Secretariat. With much delight, may we now first invite Mr. Nick Chan, Chairman of the 7th Belt and Road Conference Organizing Committee of the Law Society of Hong Kong, to give us a very warm welcome to the audience. Mr. Chan, please.
Thank you. Good morning, distinguished guests, members and friends from around the world. On behalf of President Roden Tong of the Law Society of Hong Kong, please allow me to warmly welcome you to this second installment of the 7th Belt and Road Conference. Our first installment in November 2024 brought together over 500 professionals from 32 jurisdictions, and with participants calling for an encore to gather and update members and friends on new opportunities and developments for lawyers who wish to support, grow with, and contribute to the Belt and Road Initiative. Today, around 1,300 members and friends from around the world answered that call to join this second installment of the 7th Belt and Road Conference. Today, I will deliver an upgrade and an update. By way of an update, the global landscape has undergone profound shifts since we last convened in November. The international community has witnessed pivotal moments, from new scientific advances, the DeepSeek moments, to tariffs, sanctions, war, inflations, roller coaster stock markets, earthquakes, and extreme weather conditions. Towards building a greener world with green finance opportunities, nations gathered at COP29 to stand united to finalize the landmark new collective quantified goal on climate finance, committing to triple annual climate funding for developed countries to the tune of $300 billion by 2035. Year 2024 was also a super election year with leadership transitions in many countries. We see geopolitical shifts, expansions of the BRICS membership, reshaping of multilateral dynamics. It seems the only constant is change, and lawyers attending this conference wish to identify and address more opportunities and challenges to help nations, clients, and ourselves grow with the success of the Belt and Road Initiative, which is an important economic driver for over 150 countries in the world. We have three sub-themes and sessions today. First, in session 1, right after this opening remark until around 11:15, I shall return as panel moderator to explore with distinguished panelists the topic of building a peaceful and fair multipolar world to advance economies. In an era of heightened geopolitical tension, the 5 principles of peaceful coexistence offer a timeless framework to guide sustainable global progress. As legal professionals, we understand that equitable frameworks and mutual respects are the bedrock of trust in cross-border cooperation. Second, in session 2, moderated by Organizing Committee Vice Chair and Law Society Vice President Ms. Corinne Wong, from 11:30 a.m. to 1 p.m., the panel shall lead discussions to explore the promotion of green economy and the use of green and future energy. Green and sustainable finance, though relatively new, is experiencing rapid growth across global economies. The Belt and Road initiatives offer a great platform to mobilize green capital and drive low carbon development across participating regions. The transition to sustainable practices is no longer a distant goal, but a shared responsibility. Legal frameworks would need to evolve to incentivize green investments and enforce climate commitments. Third, after a lunch break from 1 to 2 p.m., in session 3, moderated by Vice President Amirali Nasir from 2 to 3:30 p.m., the distinguished panel shall delve into advancing scientific and legal technological innovations. From AI governance to digital trade protocols, the fusion of law and technology will shape how economies grow inclusively. Hong Kong's recent generative artificial intelligence and application guideline, technical and application guideline released by the government's Digital Policy Office exemplifies how localized governance framework can foster innovation while addressing risks like data bias and security breaches. Our panelists and guests' expertise breaches jurisdictions and disciplines. Whether you join us from a consular call, a corporate boardroom, a law firm, or a research and academic institution otherwise, we treasure your perspectives, which will no doubt enrich today's dialogue. So please be generous to use the chat function to send us your comments and questions. Now, I promise an upgrade. You'll be getting a free better upgrade after attending today's conference, as this is my final year as chair of the Belt and Road Conference Committee. The upgraded version is right behind me. She's already serving you as a vice chairperson of this organizing committee and is hardworking vice president of the Law Society of Hong Kong. She will take over and shoulder the responsibility as I step down. I'm grateful to her and each member of the organizing committee, the Law Society Secretariat team, President Roden, Belt and Road Conference Committee, Thomas So, at the Law Society Council, you members for your trust and selfless contribution. You will hear more from Corinne when she moderates session 2 and delivers the closing remark at 3:30 p.m. I would like to also specially call on visionary lawyer Fred Khan. Where you are. We know you here, who is on the Law Society's Roll of Honor since 2016. He initiated the formation of this Belt and Road Conference Organizing Committee and invited me to take over Baton a few years ago. I thank we love you, Fred. So thank you, members, Law Society of Hong Kong. May I wish you good health, peace, and prosperity. Back over to you.
Thank you, Mr. Chan. We will now begin session 1, Building a Peaceful and Fair Multipolar World to Advance Economies. Please welcome again our Organizing Committee Chairman, Mr. Nick Chan, who will be the moderator of this section. He'll be joined by the following speakers: Mr. Dennis Chai, Deputy Director of AALCO Hong Kong Regional Arbitration Center; Mr. Andrey GORLENKO, partner of Ivanyan and Partners; Datuk Professor Sundra RAJOO, Director of Asian Institute of Alternative Dispute Resolutions; and Dr. Thomas So, past President and Chairman of Belt and Road Committee of the Law Society of Hong Kong. Our moderator and speakers, the floor is yours.
Thank you so much. Well, good morning. Thank you again for joining us at the Law Society of Hong Kong's second installment of the 7th Belt and Road Conference. My name is Nick Chen, the chairman of the Belt and Road Conference Organizing Committee. It gives me great honor to serve you as your moderator of this important panel discussing the topic of building a peaceful and fair multipolar world to advance economies. Please allow me to introduce our 4 very distinguished panelists. Mr. Dennis Chai. Dennis is the Deputy Director at AALCO, AALCO, Hong Kong Regional Arbitration Center. Functioning under the auspices of AALCO with 49 member states, AALCO is a tangible institutional outcome of the Bandung Conference held in 1955 and upholds the principles of peaceful coexistence. Next, may I introduce Mr. Andrey GORLENKO. Andrey is the partner of Ivanyan and Partners, a leading law firm in Russia, the Russian Federation. He assists clients in dealing with sanctions and trade disputes resolutions. Welcome, Andrey. Next, I'd like to introduce Datuk, Professor Sundra, the Director of Asian Institute of Alternative Dispute Resolution. He was the immediate past director leading the operations of Asian International Arbitration Center, which is the largest arbitration center in Malaysia and the sister center of AALCO in Hong Kong. Welcome. Next, I'd like to introduce Dr. Thomas So, a man who needs very little introduction. Everyone knows him. Thomas, our past president, also chair of our Belt and Road Committee, is also a member of the National Committee of the Chinese People's Political Consultative Conference. Welcome, Thomas. With the view of making this an engaging discussion, our panelists have kindly agreed to not use slides in these discussions, so it'll be a free-flow discussion. So, ladies and gentlemen, as we gather to discuss building a peaceful and fair multipolar world to advance economies, remember we stand at a pivotal moment in history. The global economic landscape is undergoing a seismic shift. Once dominant powers are now sharing the stage with rising economies. As BRICS nations collectively surpass the G7 in share of global output since 2018. As of 2024, last year, the BRICS countries account for 35% of global GDP, while the G7 represents 30% of that. China's growth last year, 5% on this GDP, represents 30% of the world's GDP growth. Now, the transition is not without pain and friction. Escalating trade wars, punitive tariffs, protective policies, such as those targeting certain countries, risk fragmenting the very cooperation needed to stabilize this new era. Our panel today will explore how we can harness this multipolarity, not as a battleground, but as a foundation for fair growth. Without further ado, let's begin. Question one. So, prerogative of the moderator, let me ask this question to Andrey and Sundra RAJOO. Other panelists are welcome to chime in. It is said that trade is a bloodline for advancing economies. The recent spate of so-called reciprocal tariffs have caused shockwaves to stock markets, affecting investors, business, and consumer confidence. With contract cancellations and increasing questions regarding trade financing, force majeure events, and how best to resolve disputes and differences. Now, just how can economies navigate these challenges in a way that promotes fairness and cooperation? Over to you two gentlemen. Thank you. Andrey, please go ahead.
Thank you very much, dear distinguished chairman. Thank you very much, dear distinguished co-panelists. Thank you to the participants of this webinar. So I think this is a very interesting and proper question to kickstart our discussion today. In my opinion, we are now obviously facing the crisis of international institutions, and this crisis started not today and not yesterday. I think we now watching the big crisis that is following the long-lasting disease. Of course, some mechanisms that are provided by international law are still working, but the question is how efficient they are, whether they are efficient to provide the necessary remedy. For example, I would say that China absolutely correctly, in accordance with the relevant provisions and mechanism, has applied to the World Trade Organization with a request for consultation in regard of the tariffs quite recently. And hopefully this mechanism will work. But if even consultations fail, there will be the first instance adjudication that might work properly. But we all know that the appeal mechanism of the World Trade Organization doesn't work. So the question is that ultimately the whole mechanism is not working effectively. So we're again facing the crisis. So it looks like we need to find solutions, because and these solutions shall be complex. No single solution can provide just a solution for the whole crisis. So we need a complex solution. It will take time. Whether we'll be able to reach it globally, I don't know. When we don't know, and when it will happen. So in the meantime, I think we shall be looking at the new opportunities, developing new connections, new links, although it might be difficult culturally. Of course, it's usually much easier to go in the comfortable, usual way. But I think that even the blood that cannot reach the heart tries to find some alternative ways and try to go other way. So what we learned in Russia during the recent years is that we need to step out of the so-called comfort zone, work hard, cherish true friendship, true relationships. And if you follow this way, you become more resistant to these challenges and more strong. And as you correctly say, the role of international organizations such as BRICS is growing. And even if the world will not be able to return to some global rules, global stability, we need to rely more on this regional or cross-regional friendly unions and cooperation forms that will allow for economies to grow and to function. So I think it's also the time of the new opportunities for the lawyers and for legal profession, as well in general, as well as for arbitration community and dispute resolution community. It is important that in the world where politicians are emotionally driven, we need at least to keep and develop existing institutions that will still allow the fair, impartial, and what is not less important, efficient dispute resolution, keeping them truly impartial and cold-minded in these times. For example, you mentioned force majeure and other impacts of this crisis. I think that this crisis can be used also in bad faith actions. For example, when some of the parties will try to avoid contracts without proper reasons. This can harm economies and economic relationships even more than the crisis itself. So what is needed in such kind of situation, and to keep the blood running through economy, efficient and decisive methods that I think only truly international dispute resolution methods such as international arbitration can provide. For example, emergency arbitrator relief can help in such situation and can keep the economy working and the blood going through these veins in a proper way. So I think these can be the solutions that we shall follow, and we shall stay optimistic, cold-minded, as I say, and keep being professionals. Thank you.
Thank you, Andrey. Sundra?
Yeah, thank you. Good morning, everyone. Thank you, Nick.
Thank you.
I think the important thing, I agree with a lot of things that Andrey had said, and it makes a lot of sense. But I think we have to look at the background of why it is happening, the distrust, the disrespect for multilateral institutions that have actually preserved peace over the years since the Second World War. In fact, I'm so shocked that the person who's leading that is a leader of the country that actually forced the rest of the world to fall into place and have this multilateral institutional arrangement. But I think it has to be seen or in the light of what is happening in this century. In this century, Asia is becoming ascendant, and I believe that the reaction for that is causing all these things. The competition of Europe and America is not important anymore, but rather almost like there is a negative attitude particularly in America, looking at the ascendancy of Asia. So I think one of the things that we have to deal with, we have a person who's a disruptor. President Trump is what I would say one of those great disruptors, but I don't think so he has a plan. All he has is transactional arrangements. He wants to transact, and he thinks that if I beat you hard enough, then you will transact. But actually, in reality, I think we have seen over the last 2 months, there has been an erosion of business confidence. And I think, now that we are all talking about how is trade financing going to be done, what are contracts, can contracts be enforced, how are we going to resolve disputes? And then I think, states, national states, which was the setup that the original agreement came about, because I think after the Second World War, France, Britain, America, who had great colonial empires, decided to create all this, let go and set up this new system. So I think, again, now economies actually must adopt a multilateral approach, and we have to have some rule-based strategies. We have to mitigate these shocks. And I think the most important thing, as long as we don't use force, we use fairness and cooperation. So I think one of the important things is that this recent growth in Asia particularly was based on the World Trade Organization, which was the critical institution. And I think even the ascendancy of China is due to the World Trade Organization. And I think the dispute resolution arrangement in the World Trade Organization has been quite successful. But I think for national security justifications, America, the United States, has refused to actually appoint the members to the appellate body. So basically jam up the entire process of dispute resolution. And I think, in that situation, again, I think, Asian and other countries that are affected, including, will have to actually form coalitions and try to actually deal with unilateral tariffs. That's what is happening now. One way of dealing with unilateral tariffs is to impose reciprocal tariffs, but it doesn't work. It's like hitting somebody, and then the person is hitting you, and then you hit back again. And where does it stop until somebody drops, is it? I find that maybe then I think better to call friends from the side. Can you come in and help us? Let's form so that we don't get hit. Maybe we can do work together. I think I see that kind of ideas that we now have to look at in a more urgent way. I think it also suggests there has to be dialogue, but I think a lot of people don't want to negotiate under a transactional arrangement, which is bullying based on intimidation. I think that is one of the difficulties that we have at the present moment. Things are not so clear. What is the long-term? We know that there is a feeling that certain kinds of industries must relocate. But I think that is not good enough. Everybody has their place in the sun. So I think the time has come that perhaps we should have more dialogue, but dialogue within regional groups, trying to fend off or hold together as one voice. And then I think the emphasis will be this multilateral way of rule-based approach. There cannot be a gunboat approach, which is basically what is going to be now, looks like it. Thank you.
Sundra, thank you. I wonder if it's a good time to bring in Dr. So. Dr. So, in response to the points made, what do you think the role of the Preparatory Office for the International Office for Mediation could serve in this regard?
Thank you, Chair. Good morning. Thank you again for hosting this very meaningful seminar for Nick Chan for doing this. When we're talking about mediation, I think that people in Hong Kong, local legal professionals, Nick, and people sitting around here listening to us are aware that the concept of mediation has been actively promoted actually by the government at least 10 years ago, when the general commercial community were encouraged to sign a mediate pledge basically agreeing to use mediation as a way to resolve dispute before they resort to the other type of more antagonistic dispute resolution method like litigation or arbitration. Now, so that happened more than 10 years ago. And looking at the development of the way how commercial disputes have been resolved, one can see that over the past 10 odd years, particularly in the Asia regions, there is a trend for people to try to adopt a more, how should I put it, a peaceful, way of resolving dispute in a sense that one usually find that if we use court litigation or even arbitration to resolve a commercial dispute that arise out of, for example, a very long-term working relationship, not to mention, the family type of relationship. As long as the relationship entails or include some kind of sentimental or long-term relationship there, using a kind of antagonistic approach. Sometimes even if you use that method, that dispute has been resolved, but then the relationship is destroyed forever. People find it more difficult to work again together in that relationship, even you have got a judgment or an award to resolve that particular dispute. So people then starting to find that can we not use a way to resolve the dispute at the same time preserve the relationship so that parties can still work together after this particular dispute has been resolved. So mediation comes up, and many enterprises have experience using this as a way to resolve dispute and find that they are able to preserve the relationship. And that over the past 10 odd years, we have experienced seeing that happening in the commercial cross-border dispute space. And it is, of course, very encouraging from Hong Kong's perspective to see that our central government has decided to use Hong Kong as the place to build the international organization mediation here, signifying that I think our central government very much support Hong Kong as a place to develop or further enhance this type of mediation work. And it is not just between nations and nations. And when one looks at the development of the IOM in future, I'm quite confident that they might even include cross-border commercial dispute to use their mediation services to resolve the dispute. So it's very encouraging to see that. And I think, I don't know, Nick, correct me if I'm wrong. I think there will be an official, I think they're talking about official opening later on this year, but I'm not too sure, is it the second or the third quarter? But then in general, I think we very welcome and we are very grateful to our central government for supporting Hong Kong, for using Hong Kong to do this. And we look forward to working alongside with, our colleagues in the region, in Russia, in Malaysia, and in ASEAN, and also in the Middle East to better make use of this platform.
Thank you, Dr. Thank you, Doctor. So indeed, IOMED would be something we all highly anticipate would be a great addition to help the growth of the Belt and Road. Thank you. Andrey, you might be one of the first group of lawyers to have experience in helping clients resolve issues in the trade war or trade sanction issues. Could you share with us what can we learn from that experience in terms of how we prepare clients, help clients to get out of, or to keep contracts or get out of contracts. May I? Over to you, Andrey.
Thank you very much. Well, I think yes, indeed. In the recent years, we at Russia gained some unique experience in relation to sanctions, so-called sanctions. I would say that first of all, I would not like to call these sanctions, because truly sanctions should be international sanctions provided by UN. What we have here, the same as unilateral tariffs that we were speaking just a while ago, we have these unilateral one-sided restrictions that are being imposed quite voluntarily, without proper legal background and without proper basis, even factual basis. Sometimes, and I will come to this, in a strict contradiction with the rule of law. So I would like to share the example of the personal restrictions, personal designations that happened for the last years. For example, European Union has imposed so-called sanctions, which I would call restrictions, against more than 2,500 of people. You need to understand that behind these people, it can be businesses, companies. So it affects not only their personal life, but also huge businesses, companies, but personal life also, because among these people, it can be relatives, children, anyone. And do you think that it's really possible to analyze and make the proper research to impose such kind of restrictions in regard of 2,500 people within a few months? Of course not. So when these people now try to challenge these sanctions, they are able to request from the European Council the files on the basis of which these restrictions were imposed. And what they see that it's absolutely of poor quality. So some time ago, I would maybe make a joke saying that maybe it was compiled by artificial intelligence, but I'm afraid that artificial intelligence nowadays can cope with these things better than people in the European Council who do it. So it's usually the random collection of yellow press sensational articles, and that's it, without any probative value. At the same time, there are mechanisms provided, for example, by European laws to challenge the sanctions. We're all speaking about the rule of law, and when we speak about European law, we also presume the rule of law. But what happens in practice? First, the administrative mechanism of challenging doesn't work at all. European Council doesn't simply ignores any kind of these requests. Okay, so then European Union has the special court, European Court of Justice, which is the supreme judicial body. But there are a lot of obstacles for challenging these sanctions with the court, because in regard of Russian regime, for example, European Union decided that they will be renewing the sanctions, individual sanctions, each 6 months. So what it means that you need to challenge each of this renewal, and it's like chasing your own tail. So you cannot, in time, challenge this renewal, because while your case is being considered by the court, the new renewal comes, and so it can last for 2-3 years without any result. So the people who can afford this, they need to find lawyers. They need to spend hundreds of thousands of euro to pay the lawyers, to find payment mechanism, because to pay is very difficult. The lawyers shall receive the licenses from the authorities. So there are a lot of hurdles just to give the proper protection. And even when you succeed, and I will say that my colleagues have this kind of examples, when, for example, the court has European Court of Justice has annulled these restrictions in regard one of the persons 2 times, but each time European Council ignored this annulment and renewed the sanctions. without any justification. So there are two judgments of the European Court of Justice, for example, in regard of the one person, but this person is still in the list without any explanation, any justification. Where is the rule of law here? Nowhere. So, and it's ridiculous. And we can only imagine how many people among these 2,500 of people are also not justifiably listed. So all this creates very bad examples and very bad signals for the economy. And as I said, we all need to think about this and to bear in mind these examples when speaking about rule of law, about all the things that we were used to for a very long time. But now we need to face this reality and remember this. Thank you.
Thank you, Andrey. Andrey, can I have a follow-on question for you? Do you think for young lawyers, especially in terms of the future professional opportunity, do you think trade lawyers and sanction lawyers would have a lot of business going forward? How long do sanctions or as you said, unilateral sanctions last for typically?
What I see is that at least for now, the lawyers who are involved in, for example, challenging sanctions in European Union in regard of Iranian regime, yes, that was for many years, or some other regimes, they're quite experienced and have quite a lot of work nowadays. Being optimistic and looking for more fair world and more cooperative world where we will be more focused on trading, on scientific development, on innovations, on doing some interesting things instead of doing sanctions. I hope that this profession will not be so popular in some years. But do I have grounds to say this? I don't think so. In the coming 5 years, at least 6 years. In any event, I think it's a very interesting sphere that develops a lot of skills, especially even challenging the sanctions. It's still a kind of proper litigation work. So each lawyer who deals with it, first of all, needs to know how to work with the facts, how to challenge the probative value of the evidence. It's the proper work that you face in any kind of dispute. So by having this kind of experience, among other experience, will not leave these lawyers without work further, I think. In any event, it helps to develop professionally. And even if everything goes well and the world will come back to some kind of normal, I think they will not be left without the work.
Thank you, Andrey. I'll maybe now turn to Sundra. But before that, I'll remind members, Andrey talked about whether AI will be evil. So please stay for session 3, where we talk about law and AI developments. And over to Dr. RAJOO. Andrey talked about how unilateral impositions, so-called sanctions, are against international law unless they are approved by the Security Council of the United Nations. I believe that's what Andrey is saying. What do you think of that, and what do you see in Malaysia? Thank you.
Malaysia, I think it's different. We have different expectations. I suppose, the state as a policy, for example, Israel and Palestine, they always take the Palestinian position. So Israel will always be seen as aggressor. It's a national policy and attitude. But, of course, I think, one thing about sanctions is that we also realize that there is such a thing called global norms. And sanctions are now used to actually enforce those global norms. And whether it's a global norm or not is where you stand and look at it. But I think there is a general consensus there are certain kinds of behavior that will not be accepted. And I think, for example, acts of aggression. And then I suppose there is also, I see that sanctions are going into punishing people for what's that, a violation of human rights. The real problem about sanctions is how efficacious it is. And I think whether it's legitimate, whether it's efficacious, and whether it is right under international law, whether it's allowed by international law to do that. Or you see, the problem with the Security Council, when you look at Chapter 7 of the United Nations Security Council, they actually can impose binding sanctions, but it's subject to veto powers. You can see the way it works. So at the end of it, while they want to maintain international peace and security, the council's decision we sometimes see is compromised by political considerations. So I think that sometimes there is a suspicion that sanctions are being used selectively to punish people. So I think that is where the real problem, the real thing, it goes back to how do we ensure all these sanctions that which enforce a global norm is actually not abused, and it is in compliance with the international legal framework. It has that. There must be some kind of consensus. When you impose a sanction on a person who is actually economically productive, you try to actually cripple the economic productiveness, punish the person in such a way that it cannot contribute to the national interest or whatever it is. So I think that is one difficulty, and it is actually also affecting the human rights. On the other hand, sanctions can affect innocent people. Innocent people who look at Venezuela, sanctions that are put onto Venezuela. But look at the number of people and their citizens who are actually starving and dying. So, of course, like in North Korea, there's exemptions for medicine and certain kinds of food and all these things. But I think that we have to rethink this thing. How do we have a robust accountability mechanism for sanctions? And this, I think, is the debate that goes on. And sometimes we personally have friends who are sanctioned. And why are they sanctioned? Because they did something that someone disagreed with, not fitting that norm. And then the person is actually not allowed to be doing things that are productive for the world interest, which I think is terrible. I'm watching this. In fact, I see it's terribly unfair. I believe that it has to be, I think we need to sit down and have a dialogue on how to make it efficacious. I think certain things we must respect national sovereignty to certain decisions, but on the other hand, we also must preserve certain norms, but it cannot be so wide because value systems are different in different societies. So I think that is been troubling me more because I do international arbitration, I do sanction arbitrations also, and I feel that people just want to get on with their lives. Why are they being punished commercially?
Thank you, Datuk. Datuk, you mentioned innocent individuals are being harmed. Let's turn to lawyers who are sometimes being harmed. Some lawyers are sometimes being targeted and punished solely for serving their client, filing cases against some authorities or countries' wishes. How should legal institutions or countries protect the rights of lawyers to represent their clients? Does anyone like to comment on that? Dr. So, thank you.
Thank you, Chair. I think it is not uncommon these days, but then a little bit surprised, to seasoned lawyers to see that quite a few private practitioners or government lawyers or even judges got all these threats or sanctions by various, by some jurisdictions, some government. And this to some seasoned lawyers like ourselves, Nick and ourselves, we've been practicing for over 30 years, surely, also Andre, people sitting around here, it took us by surprise. How could this happen? So
Right.
I think on behalf of the Law Society, Hong Kong Law Society, there's a few points that I want to bring out, general principle. It's very simple. First, lawyers are legal professional service providers. Lawyers should not be criticized, threatened, or attacked just because they're doing their job. All right? What they are doing is to represent their client's interest in accordance with the laws of their jurisdiction. They're supposed to be doing that, and they should not be criticized or attacked just because they're doing their job. Otherwise, why do we have lawyers? We might as well just scrap this whole legal profession altogether. And second, lawyers who represent their clients are not only doing nothing wrong, in circumstances that I have just described. These people were attacked or sanctioned or what have you, but they are doing exactly what they are supposed to do to ensure that the rule of law is upheld. Lawyers are there no matter who you are. Okay, if you are representing the client, you act in the best interest against the government, against big corporations, against the others to pursue the rule of law. Because we all believe that no matter how big you are, how powerful you are, how rich you are, everybody is equal before the law, right? Thirdly, languages or actions unfairly undermine the confidence in the legal profession. In fact, undermine the confidence in our entire justice system and the rule of law. So because of this, I think legal professional bodies, we have seen our president and also other leaders of the legal professional bodies, they need to speak out whenever they see things like this happen. Because you need to speak out to let the people know that this is wrong. Because legal professional bodies should only adhere to the law, international human rights law and standard, and also they need to maintain the highest professional and ethical standard so as to protect not just their clients' interests, but also the membership, the legal professional members, to protect them from improper restriction and infringement. And it is the duty of the legal professional bodies to do this. And at the same time, I think the legal professional bodies also need to educate the public about the principles of the rule of law and why we are doing this and why do we have lawyers in the first place? Why is it important in a jurisdiction that lawyers exist and what lawyers do? I think that is important. And then finally, very importantly, is to ensure that the legal profession is independent, because independence of the legal profession is key to the rule of law, to protect the members, to ensure that members can perform the duties in accordance with the law, free from any interference. And for example, in Hong Kong, I think our legal profession is self-regulatory, and that is very vital for maintenance its independence. And the self-regulation of the profession also enable the profession to take an objective view on legal matters, on social matters from a legal perspective. Thank you.
Thank you, Dr. So. Anyone else like to add to that?
Sorry, can I just say it sort of
Sure.
brings to mind this adage, what Thomas is saying, that don't shoot the messenger just because you don't like the message. Because lawyers are actually just presenting the message for their client, but they are not involved in it itself. Because you are there, I think Thomas has put it very well. You need an independent people who are prepared to actually present that message. And nothing wrong with that. In fact, our system, rule of law, works on that basis. That there is independent system. But I think but at the end of it, you still have to go back to the system to check whether it's legal. And then you have to actually tie back with coalition building and perhaps engage with the policymakers. Why do you hate the message so much that you have to shoot the messenger?
Thank you, Andrey. Thank you, Datuk. Andrey, I saw you unmuted. Please, would you like to share a few thoughts?
Yes, thank you very much. Actually, I share fully the views of Datuk Sundra and what Dr. So said, especially about self-governance of the legal profession independence. So I think this is the key. So the more self-government works for the legal community in one particular jurisdiction, I think the better is for the rule of law and for is the best guarantee that in this jurisdiction we will not see what you are saying about lawyers being under pressure. So answering your question about safeguards that legal institution can provide, I would say that I don't trust much in some kind of international institutions here. And for example, IBA showed this recently. Again, in regard of Russia, it was a good example. So I believe in exact legal societies, in exact jurisdictions, or even in exact regions or cities. For example, another example that we faced recently is that when UK, European Union started imposing as part of these so-called sanctions, the restrictions to provide legal advice to Russian clients, Russian companies, to any, even if this company is not under sanctions, they cannot get any legal advice on any non-litigation matter. Yes. So there are only 3 bars in Europe who was strong enough and brave enough to try to challenge this restriction, saying that it's against the rule of law and against the principle of legal profession. It was the Paris bar, the Brussels bar, and the Geneva bar from the Switzerland. So it showed to us that these old school legal professionals with very strong traditions of legal profession, they turned out to be real fighters for the legal profession, for independence and for self-governance. It was a little bit surprising for me that the UK legal community, who were solding their legal services quite successfully for many years, didn't try to do anything about this. Although, of course, in any community, we saw lawyers, proper lawyers, who were ready to continue their professional duties, who understood that it's very important to provide proper legal assistance to any persons, especially in such kind of difficult, challenging times. But of course, there were a lot of obstacles, and unfortunately, in some of these cases, the legal communities were not very supportive, but in some they were. So I think it's very country-specific, very specific to the society, to the culture. So I think we need to keep this culture, to keep these traditions of legal profession, to teach young lawyers these lessons, because when I was talking to, for example, these European lawyers who challenged this, they were saying we were taught like this. We were taught that the lawyers shall provide assistance to any clients, and I was also taught like this from my teachers. So I think that's what we need to give to the new generations.
Andrey, do you see Hong Kong as a great location for disputes resolution for companies from the Russian Federation? And second
Yes.
question, yes. Second question is you have I think a Russian arbitration week coming up in May. Is that shaping up as a local event or an international event? Thank you.
Thank you very much for these questions. First of all, of course, Hong Kong is now, I would say, top priority to go to negotiate as a place to resolve disputes for Russian companies. So that is undisputable, and I know and I see a lot of arbitration clauses referring to Hong Kong, although of course there are other seats and places that parties can negotiate, but this is a top priority. As for the Russian International Arbitration Congress, thank you very much for bringing this to the attention. It's a truly international event, and I hope it will be very successful. We see already a lot of participants coming from all over the world. We think it's a good moment, and we see the interest growing. We see that a lot of international institutions are coming. HKIC, for example, they're doing their event. Singapore Center, SIC is doing their event. So it's a great honor that Mr. Chairperson Nick Chan, you also will be coming. And I invite everyone to join either in person or virtually, and I hope that this event will become regular, and I hope to see you all also in a year and in 2 years, and I hope it will become a good tradition.
Great. Now let's turn to Dennis. Sorry, didn't mean to ignore you, Dennis. Now, the Global South now accounts for over 40% of the world's GDP. Which emerging markets or regional partnership do you see are new opportunities in today's world from where you're sitting from the AALCO 49 countries world? Thank you.
Thank you, Nick, and thank you so much. And indeed, I have learned a lot from fellow members' excellent discussion. I prefer continue my learning and listening instead of speaking. But since Nick asked me a very good question, and Nick is my director at AALCO, and Nick is also heading the operation of the AALCO Arbitration Center in Hong Kong. I must try my best to answer Nick's question in terms of talking about emerging market and opportunity. And by way of background, I studied economy and trade before studying law, and I worked for arbitration community for more than 20 years in the past, and I have been observing where our clients are coming from, who are the users, where are the users' jurisdiction. So these are the kind of business sense, and I think that good lawyers always have good business sense. They could be very good businessmen. Since we're talking emerging market and new opportunities, I'm thinking about how to answer this question. And first, I think we should know who are the current users of arbitration's international legal services in Hong Kong. And if you look at the HKIAC's annual report, it always lists out the top 10 jurisdictions where the parties in dispute from. And this might be a good indicator telling us where our clients from, what are the major jurisdictions using Hong Kong's arbitration services. From the latest statistic last year, Hong Kong is the first place, and also mainland China ranked the second, and then BVI, Cayman Island, because we can imagine many companies who are incorporated there for many good reasons. And also Singapore ranked the fifth, and also United States and UAE and also Thailand, and these are the major region or jurisdiction using Hong Kong's arbitration services. That could be a good indicator. So we are now knowing that there could be, it could not cover all the places in the world. Like, for example, there was no African parties using Hong Kong arbitration services ranked or listed in the top 10 jurisdiction. So this kind of pattern or list is almost similar every year. So we know that clients are mainly from South Asia, mainland China, and United States, and all these jurisdictions are major trading partner of China, because China's economy is so good, and which trigger a lot of dispute which may call upon for good arbitration services of Hong Kong and legal services of Hong Kong as well. So this is the current situation. But looking forward in response to next question on what are the emerging market, I think some of the current markets still continue to boom, to thrive, because of the digital economy is growing in Asian or in ASEAN or in Africa in particular. So this could be this new economy development could help providing continuous support to the development of arbitration services in Hong Kong. And like, for example, South Asia, the internet economy is predicted to hit $600 billion by 2030, driven by the high mobile penetration and young tech-savvy population. So these are the new economy that we are confident that they will continue to use Hong Kong dispute resolution service and legal service, and choosing Hong Kong as the seat for arbitration, for no doubt. And moving forward, in Africa is the new market that we should pay more attention to, because it is not listed in the top 10 jurisdiction. There's no African country being listed in the top 10 jurisdiction using Hong Kong's arbitration services. So that does not mean that we would ignore that that region. On the other hand, we should pay more attention, pay more focuses on this area. In Africa, fintech revolution has found a stronghold in a population of 1.2 billion people, possessing by far the youngest media age in the world. So today, 17% of the Saharan Africa is under age of 30. So, and this young and motivated workforce offer potential rapid economic growth. So this is definitely Africa is is an emerging market, an important market to Hong Kong legal services as well. And countries like Nigeria, Kenya, and South Africa are in the leading position in driving this change. And also the recap market, no need to mention, Belt and Road. There are so many overlapping with the AALCO member states, and we all know that there are 49 member states of AALCO, which are all active participants and contributing to the Belt and Road initiative initiated by China. And in terms of the economic sector, and we may know that there are, in the old days we all rely on traditional economy pillar like construction, shipping, international trade, logistics, etc. But nowadays we have new economic sector and development like the low latitude economy and renewable energy and green economy, etc. So these are the different sectors in our emerging market, which developing very fast. And of course, Hong Kong has all the benefit and advantages to grow its economy with its connection to the world, and with its special as a springboard to mainland China market as well. So Hong Kong will be continue a good emerging market and to Hong Kong legal and arbitration services as well. So here maybe I would like to have a stop here, and then to listen next and any further direction and any views from our fellow panel member. Thank you, Nick.
Thank you, Dennis. The world have seen some countries withdrawing from global institutions like the WTO or ICJ, because of what one might then consider a unfavorable ruling. But that would have a destabilizing effect on the world. And how do we cope with this? How should lawyers and nations, clients prepare for this? Datuk Sundra, would you like to answer that?
Actually, I think this is the real danger of people withdrawing support because they do not like what the institution is doing. They do it in two ways. One is that they stigmatize the operations itself by saying that, look, I'm not going to let this particular function, but I have a power to appoint. For example, WTO, appellate body. I think that is quite a disgrace. In fact, I think it's a terrible thing where a country that is responsible says that I don't want disputes to be resolved. So when you cannot have disputes to be resolved within a framework that was originally agreed, then it becomes very, very difficult because then it's difficult to maintain the legitimacy. The other thing is cutting of funding to international organizations is also now seen to be, of course, we now see a cutting of funding to even national organizations within a country. So it's basically, I mean, they are basically saying that, look, we don't want regulation, we don't want oversight, we don't want ways of doing things. But when you actually cut funding, the institution actually weakens. So how do you actually sustain that? So I think there has to be other ways of looking at how things to be financed. There are certain institutions by international law should be held sacred, and it should be funded in such a way that perhaps it's not dependent on total funding on a particular country or sovereign country or what it is, who can use it and say, I don't like this. The other thing is that there must be actually some agreement on the global norms. I think there is a breakdown on what it should be the global norm now. I think that this year particularly, I think where trade is concerned, economic trade is concerned, there's a breakdown. Almost like everybody is like scrambling on a one-to-one bilateral basis, and that is very difficult. So international organizations are under threat. I really feel they're under threat. They have to actually find new ways to finance themselves. They have to find new ways of making themselves relevant. And what will be acceptable to them, to the countries that actually have now changed their mind about how this institution should function. So I think now there has to be that dialogue to recreate, rebalance, recalibrate. So I'm not sure what is going to happen. It looks like a very dangerous time for all of us. A very dangerous time. I just feel that there's this gap now. It's happening, and we have seen accidents like this in the 1930s. I mean the imperialism that you saw at that time, the expansion and all this is based on a perception of being badly treated, economically poor, and then after that, no institutions working, and then the only way to settle disputes was to actually use violence, and then an idea of acquiring territory, acquiring economic assets, and all these things. So I think that is the one that we have seen. The old order, which is now I call it the old order, was supposed to preserve, is now got to be recalibrated to a new order again.
Although you refer to events leading up to World War II, which is a chilling effect on all of us. And you talk about one by one, it's very tough on countries. So do you see any benefit in having regional cooperations or collective discussions towards a more open and multipolar world?
I think now it's going to be regional blocks forming. For example, I see two good examples in Asia, particularly. One is actually ASEAN, which is ASEAN is Southeast Asia. A number of states in ASEAN have formed an economic bloc where large population, and then there is actually BRICS, which is another economic bloc of countries of a particular size, and there is overlapping membership. So the interest is actually merging. The basic attitude in this thing is that internal affairs you don't interfere, at least in us. what
Mm.
you do in your country is your business. It's your
Mm.
family. You take care. I think that
Mm.
has actually helped to create this consensus building all the time and the
Mm.
together. And look at the
Mm.
population that we are talking about. I
Mm.
think we put BRICS and ASEAN together.
Mm.
We've taken more than half, maybe 65% of the world population, productivity,
Mhm.
and other things.
Yes,
So
yes.
I think these two institutions, I think we should spend more time building it,
Mm.
building it up, and find that consensus that exists in these two institutions, how they work together, and maybe recalibrate using that. Forget about maybe the old institutions because it's been torn down, and look
Mm.
at these new institutions. They are made in the image of the other institutions, but more
Mm.
importantly,
Mm.
there is actually sectorial and regional interest, which is very
Mm.
important, I think.
And of course, in terms of blocks or cooperation-wide regional cooperation, there's of course the Belt and Road Initiative, 150 plus countries. Can I invite Andrey to also chime in on this? I know it's very early for you, time difference and all.
Yeah,
Maybe next year you'll be here in Hong Kong for this. Yeah.
yeah, it's a pleasure. Thank you very much, and I fully agree with what Datuk Sundra RAJOO was saying. I think that regional alliances now are really important and becoming more and more important. This, of course, it's very important how many population, and I fully agree here. But as I said in the beginning, what matters now is a true cooperative and friendly relationships. And so we see that within these alliances, we see these kind of relationships, and we see strong partnership, and it's beneficial for all of the participants of these alliances. So when we speak about multipolar world, so we see that these kind of alliances show how we can function. And Datuk was absolutely right saying that so all these alliances, they respect the way how the members behave and what they're doing internally, but they're focused on their cooperation externally. And it's also important that this kind of mechanisms, they can provide favorable solutions for less for the small economies, because instead of going to bilateral relationships, bilateral treaties, where it's sometimes difficult to negotiate when they are becoming the part of group of countries, part of this alliance, and when the mechanism of agreement is multilateral. So it means that it's more fair for all the participants, and in this situation, the small economies can enjoy the same fair, equal rights as other members of these alliances. And at the same time, they can also use this as a kind of support with in their relationships with the countries outside of their alliances, because they can always try to choose to enter into some kind of relationships either bilaterally or together with other members of this alliance, and negotiate together the better opportunities, better conditions. So I think the future is indeed in these kind of alliances. At least, as I said, in the short-term perspective, I agree we should focus on them, because it's not obvious that we will be able to return to some global solutions in the nearest future.
Thank you, Andrey. Just now, Dennis spoke on opportunities in regions like Africa, where the cost of labor is relatively lower, a very low average age, and therefore strong productive force. But don't forget also Indonesia, big country with a very low average median age, and of course our friends in Malaysia. Always been a good friend of the Belt and Road and Russia as well. A observer state of AALCO. Now, Thomas, Dr. So, You were at the in Beijing in the two sessions. So I'd like to touch on seek your help to guide our audience. Apart from regions that have opportunities of growth within the Belt and Road, what about sectors, industry sectors that are opportunities for growth that lawyers joining this course should pay attention to and plan ahead or get more involved in? Thank you.
Thank you, Chair. I think many of us have also attended a session. I think you were the speaker, Mr. Nick Chan, about what people need to pay attention to following from the two sessions. And I think in your sharing, there are various areas that the two sessions mentioned, which are highlighted. I think that for the benefit of us here, sitting around here from Hong Kong's perspective, I think the financial sector was highlighted as one of the most important area that Hong Kong should focus on, and hence professional service providers like lawyers, accountants, bankers, investors could take that into account. But at the same time, I think the message that we got from the two sessions is that one needs to think of ways to kind of innovate, to skill up, so to speak, to take our position to the next level. So when one looks at financial sector and people who are involved in that field, I think the message that we got is that don't just be complacent. Don't just be complacent. You think of ways to kind of innovate, to bring your business to the next level. And I think that applies to professional service providers, including lawyers. That is something that we bring back and remind our members to think of that. And by upskilling our ability, our professional ability, what does it mean? So when we look around, apart from financial sector, we also see a lot of encouraging words and encouraging development area of growth in the AI space. I think the AI plus is a key term that one can find from the government reports that we discussed in the two sessions. So technology as a way to upskill professional services is the way ahead, I personally think, for a professional service provider. So looking at more widely from an investment point of view or business point of view, so looking at that is AI plus, upscaling of professional service. Green industry, I think green industry, because we talk about a lot of investment in terms of green project, green energy and what have you. And I think those are the area that I think I can share with all the others, and of course subject to any points that I have missed, Mr. Nick Chan, Chair, would supplement.
No. Thank you very much, Dr. So. That delves well. Session two about green finance and green economy. You'll hear from Congressman Frank Chan later on, who would share a master plan for the country that he proposed that would have a lot of opportunities for professionals. And earlier, I also want to touch on in terms of geographical or geopolitical issues, and trade tariffs and so on. If you today manufacture in South Africa, you could sell products to the US pretty much tax-free. And I guess one should also think about RCEP, when we talked about regional cooperation earlier, that Sundra led a discussion with Andrey. With RCEP, very soon, if you make if 40% of your content is made in these 15 countries, and hopefully also soon Hong Kong as a jurisdiction, then you could export them tax-free into the other 15 countries in Asia Pacific. And if you make 40% in these 15 countries, 60% in South Africa, and using low average salary in, say, Egypt, which is $1,000 a month, then you could pretty much make things using good technology, green technology, and ship them worldwide. Because if you're making, with some help in Egypt, along the Suez Canal, for example, you could sell them to many European and Arabic countries tax-free, and make some in South Africa, sell them to US tax-free, make them in China, Hong Kong, Malaysia, and so on soon. You can sell them to 15 countries tax-free. So that would be great opportunities, and I think members should go to these places and organized by the law events organized by the Law Society and see a bit more. Now, if I could turn to the next topic, subtopic. Oh, but before that, can I invite attendees on this conference? Now we have close to 1,300 who have dialed in, joining us through the online platform as planned. Please send us your questions. This session will end at 11:15. So it's a good time for you to send in your questions so we could present your questions to these distinguished panelists to guide us with their thoughts. Now, may I ask this question? How can international organizations help build a peaceful and fair multipolar world to advance economies? Would anyone like to take that up? Maybe Dennis?
Yes. Thank you, Nick. I was trying to pick it up, and actually, I think I'm as AALCO, and we should say something on this very typical question, because international organization it's very important, I think, in the nowadays world, which is changing very fast, and I want to share some of my observation on the inception of the AALCO Hong Kong Regional Arbitration Center. And most of us have know about this organization is established by international law, because I have been working for several arbitration centers in Hong Kong. And all of the arbitration center I worked before were established by local law in Hong Kong, company law. And they turn to a charity, and then making it and have a very good governing board by members from various professionals. So that these are the success of the arbitration centers operations in Hong Kong for the past many decades. Nowadays, the world is changing very fast. Why we need to have an AALCO Hong Kong Regional Arbitration Center as an international organization set up in Hong Kong under international law? So this is a very good development and for Hong Kong arbitration, and increasing the diversity of arbitration center. And I know that Datuk Sundra RAJOO is also have I think he may supplement and correct me if I make anything wrong. And AIAC is also a member of AALCO, and AALCO is an intergovernmental organization. It's the only intergovernmental organization across the two continents, Asia and Africa, comprising 49 member states. So this is a very and it also has a very long history. It was founded in the 50s, last century, and after the Bandung Conference in 1955. And AALCO has always playing a very important role in public international law. But the fact is that many of us in private practice may not know about that, but AALCO is very famous in public international law. Now it's also very famous in private international law as well. And AALCO Center is for arbitration has been set up since the first one in AIAC, previously known as KLRCA. So, and all these centers play a very vital role in providing country-neutral dispute resolution services in resolving dispute arising out from the region. So this has a very good cornerstone to guarantee the healthy and development of the region's economy. So this is it plays a lot of it has done a lot of things for promoting the facilitating the development of the economy in the region, in particular in Asia, in Africa. So now with the AALCO Center in Hong Kong set up in the AALCO Arbitration Center set up in Hong Kong, and I think that we form a bigger family. We have an AALCO dispute settlement system comprising 6 arbitration center in first one in Malaysia and Kuala Lumpur and Cairo and Nairobi, Lagos, Tehran, and Hong Kong is the newest one. And we work as a family, and we have very good experience in handling regional dispute and government to government dispute and government to business and business to business as well. So this is very good development in Hong Kong's arbitration's history. And we have talked about the sanction at the beginning, which I enjoy a lot of listening. And then we move on to talk about the economy opportunity and emerging market. And sanction is a kind of threat. We have know about that. And in this fast-changing world, why we have to rethink why we need to have an international organization. I think one of the benefits is that it is very safe. We enjoy privilege and immunity under the Hong Kong law as an international organization. Hong Kong government, Hong Kong Special Administrative Region guaranteed the independent operation of the AALCO Hong Kong Regional Arbitration Center. This is a very unique status in Hong Kong. And I'm sure that Dr. Sundra RAJOO has a lot of benefit and experience in operating the AIAC as an independent organization. And the staff there has the immunity. We have discussed a lot in many other arbitration forums and conferences whether arbitration center has an immunity. We all know that arbitrator has immunity under arbitration law in many jurisdictions. But very few, or maybe I don't know any places of the arbitration law or domestic legislation providing immunity for arbitration center. Arbitration center may get sued. The Hong Kong International Arbitration Center got sued by a disgruntled respondent. So that will create a little bit, it is not a good experience. And of course, that may harass the arbitration proceedings. That's not good. But at that time, I was thinking whether Hong Kong could have an independent arbitration center that can enjoy immunity and privilege. Until the AALCO arbitration center set up in Hong Kong, none of the center has that immunity status. So in that sense, I would like to respond to the next question, why the role of the international arbitrations, the role of international organization in this fast-changing world is very important. And AALCO Hong Kong Regional Arbitration Center is one of the very good development, and we provide truly neutral and independent dispute resolution services for various kinds of disputes. I'm not sure if Datuk Sundra RAJOO would like to supplement anything or make any comment for that.
Thanks, Dennis. You have explained it very well. One of the things when I joined KLRCA at that time, in 2010, I was fascinated by the structure of AALCO. AALCO is set up under a host country agreement with its host country being India. So first thing is that you have AALCO set up in Asia, and I think there is an arrangement that the Secretary General who is the chief executive of the organization, the position will be rotated between Asia and Africa. That was a fascinating concept at that time. So you will have one Secretary General for 2 terms, a total of 8 years, and then it switches to from Asia. Then after that, it switches to Africa. It gives that feeling because of inclusiveness. And then you have the Deputy Secretaries Generals who are from very interesting countries, Iran, China, and Japan. So I'm quite sure that this structure, there was a thought, maybe it has to be relooked again, but the fact that Iran is actually like a permanent Deputy Secretary General, it brings back, despite of the isolated nature of Iran now, especially by the West, then I see that there's this engagement that is going on. And then the idea of an international body, which actually gathers delegations and groups to discuss things relating to Asia and Africa. For me, the kind of work that has been done in international law there has been very interesting. And then, of course, there are a number of observers who are interested in how this group of people work. So I think it's a very successful organization, although people will say that, look, it is not really effective, it's just a group of people coming and all these things. But the very fact that the membership has been increasing to 49, and then I think also the soft power that the institution has, and particularly in creating its centers, the network of centers, which will never happen. And I think the special protection that Dennis talks about, that the centers themselves are institutional, international organizations within the country, where there is another host country agreement, where the host guarantees the privileges and immunities so that the institution, the center, can function freely. I think it's quite a unique experience because we in Asia and Africa don't have that tradition of international bodies growing, and we are now getting so used to it. It's like second nature already.
Thank you, Sundra. The Secretary General now is, of course, from Thailand. Now, a question from the floor, if I would say, from the online chat. When law firms try to provide legal services for sanctions clients, bank will treat the bank account of the law firm as high risk and threaten to close and freeze the bank account of the law firm. How can law firms deal with this kind of difficult situation? On the one hand, the firm would like to provide the services presumably, but on the other hand, under the threat that their account could be closed or frozen. Who best to answer this? I wonder if it would be Andrey or Dr. So. I want to have a go at answering this question from the floor. Thank you.
Well, I think it's a very good question, but a very difficult one, because here we go into the sphere of bank compliance, and I think it's very case specific and very specific, depends on the exact bank, and it's a question of, I think, relationships and the reasonable approach, because I think the reasonable approach is if the law firm can provide all the documents, all the evidence to the compliance, showing that they're doing nothing else but providing professional legal advice. They're not facilitating any kind of sanction evasion, any kind of trade or some other things, but they're just doing the legal work, proper legal work. I think any reasonable compliance should be fine with it and understand that this is an allowed services. Yes, they're not bringing any kind of transaction, they're not selling anything and so on. But of course, it's very difficult and I think case specific, as I mentioned.
Thank you, Andrey. Dr. So, would you like to add to this?
Yes, actually, we have seen quite a few of this kind of cases before. I think that one needs to look at it from two angles. Okay, first is legal compliance. This sanction threat may or may not be legally binding in a particular jurisdiction, particularly when that sanction is not internationally recognized sanction. We have seen that a lot. So first, I think from a lawyer's perspective, you ask yourself this question: is it a matter of law that I cannot take on this case as a matter of law? So that's a legal question. So if it is as a matter of law that in fact you can take on this question, then the second is from the law firm's business angle, is it a case that you would insist on taking on? And if you do so, you will be upsetting a lot of your client. For example, the banks will say, look, oh, don't touch this, because you're embarrassing us or the rest. Then that will become a business decision of the law firm. And we have seen, I think, some recent cases where managing partners of some big law firms come out and explain the decision. So I think, after all, I think law firms are legal business, and I can't argue against, for example, 95% of the partners decided not to take on a particular type of work, although strictly legally speaking they can, but then from a business perspective they decide not to. So I think I personally would approach it in these two ways.
Thank you very much. Another question here is in terms of diversity, equality, and inclusion. We've seen certain Western country having some issues over this with law firms. What do you see are the trends in your part of the world, and what are your thoughts on this issue? Anyone? Andrey?
I can briefly comment if colleagues allow me. I think that all these initiatives are, of course, good, and of course they shall be taken into account. But I don't think that they shall be damaging other criteria. Yeah. So first of all, I think the law firms shall be professional, and they need professional lawyers, so that in order to ensure that the legal services they provide are of proper quality, and this is the most important. So of course this is important to remember, not to preclude good lawyers from joining the profession, but of course it shall not be something that shall be put before the professionalism.
Thank you. Okay. So another question is, technology is transforming legal and trade systems. How can law tech help improve transparency and fairness in cross-border economic cooperation? Anyone? Oh, sure. Dennis, of course.
Yes, just a quick sharing. I think technology is productivity. There is no doubt about that. And technology used in legal sector is a very good development. And I still recall that the first ODR system set up in 2 decades ago being for domain name dispute resolution. That was it was very high tech at that time, but nowadays it is low tech in today's standard. But nowadays there is a new technology coming out like AI and used in a lot of area, and also a blockchain which can help trace the development of the contract and also help in many trading system. So that's why I would say online dispute resolution and technology used in legal sector can ensure the fairness and speediness and as well. And also, for example, the technology can help help parties to participate the proceeding easily. For example, in the time of COVID, I'm sure that Ibrahim and my former chairman Thomas will have more to share about how Ibrahim can help a party in dispute during the time of COVID. And COVID is it's a bad thing, but the good thing is it does accelerated the use of technology in legal sector. So that's a good thing. I was trying to promote the domain name dispute resolution online platform for other type of for the conventional arbitration and mediation services for a long time. But of course, I received a very limited success about that until COVID. The whole world arbitration center say they are doing ODR. So in conclusion, I think that technology is can ensure the speediness and fairness of legal process. Thank you, Nick.
Thank you.
Can you allow me 1 minute? Thank you,
course.
Dennis, for
Thank you.
mentioning EBRAM, which is an online dispute resolution center, and Hong Kong Law Society is one of the founding members. But today, as I'm speaking on behalf of the Law Society of Hong Kong, I would rather use information to talk about this aspect from the Law Society of Hong Kong perspective. And so I would like to share with panelists today that there is in fact a report released by the Hong Kong Law Society in January last year, I believe 2024, about the impact of artificial intelligence on the legal profession. Now, in this report, I think there were surveys done, and then it is undoubtedly that using AI would improve efficiency. I think it is in one of the key points mentioned in this report, because the machine learning system demonstrate that they have assisted lawyers in their due diligence exercise, in their contract negotiations, where the searching of key terms within huge volumes of documents can produce highly accurate responses in seconds. And AI can also speed up the due diligence exercise for merger and acquisition by analyzing thousands of documents. And then second, I think the report also mentioned that use of AI would improve access to justice, because by leveraging automation and reducing manual work, AI may help lower costs, generate innovative ways to provide legal services, and improve access to justice. So definitely use of technology, use of AI, law tech would improve transparency and efficiency of doing business, particularly across border. But then there are a few points that the Law Society also want to highlight, because technology, whatever you call it, AI, blockchain, or what have you, is nevertheless just a tool that a lawyer uses. So no matter what tools a lawyer uses to assist the lawyer in his legal practice, one cannot forget that his professional ethnic duties and values should not change and should not be compromised just because of using this tool. And a lawyer has a duty to act competently. And then AI tools are just tools to augment the value-added work of legal service providers, but not to replace legal service providers altogether, or not to be promoted as a mechanism for self-help legal advisory service. Now, I don't know about you guys in other jurisdictions, but we now have clients coming to us and say, look, Mr. So I have this DeepSeek analysis of my case that I want to show you. Do you agree with the suggestion produced by DeepSeek? All right. So we see that day in, day out. So this is the type of the use of AI tool by a lay client, as you know. This tool will become a kind of allow me to say amateurs legal service provider that should not be accepted as 100% replacement of professional legal services. So I think that point is brought out very clearly in the Law Society's 2024 January report.
Thank you. That's very helpful, Dr. So. Thank you so much. With that, maybe a 10-second closing remark from each of our panelists. 10 to 15 seconds. Keep it short, punchy. I promise an update, upgrade, and a 15 minutes break. So, any closing remarks? Sundra is really good at this. Sundra. Unmute first. Unmute first.
Thank you, Nick. It's one thing that I've been thinking in recent terms is that how do we actually continue in this world where there seem to be so much anger and angst among, the main players. So I think that, basically, I think we have to go back to with the Chinese emphasize always on the family, that we are a family. We are a family of nations, and healthy rivalry is within the family is good because it creates wealth, it creates prosperity, it creates growth. So I think that is very important. But there are certain things the family members do not cross. That is the family relationship. So I think there'll be time for us to think like that. In this very, very challenging situation now that we see that the family is actually, members are really like sucking it out. So it's time maybe somebody has to say, come on, we are all my family. Let's work it out by dialogue, by cooperation, and then keep the rivalry to a certain point that it doesn't actually undo the fabric that we have created over the years. Thank you.
Thank you, Datuk, Professor Sundra Arjun. Andrey, probably 4 or 5 in the morning for you. But
thank you very much. Fully agreed, and I think it's real honor and pleasure, and it's very important to have such kind of fruitful discussions in order to share the views across jurisdictions, across cultures. And I hope that we will continue this dialogue. And thank you very much for the Law Society of Hong Kong, to you, Nick, for bringing us together. Thank you very much.
Thank you. Thank you, Andrey. Dennis?
Yeah, thank you very much. First, I thank you all panelists. I have learned a lot. And secondly, I would suggest all participants to pay more attention to Asia and Africa, and as this region has great potential and a very good opportunity. And also stay tuned with AALCO, Hong Kong Regional Arbitration Center. Thank you.
Thank you. And the last word with past President Dr. Thomas So.
Thank you. We are all living in a very fast-changing and unpredictable geopolitical landscape that is heavily impacting the global economy. Resolving global disputes through healthy dialogue and joint efforts, I think, is crucial. By creating a network of cooperation that benefits all countries, I think we can pave the way for sustainable development and prosperity. Like the Belt and Road Initiative, it embodies the principles we need in this regard. It emphasizes connectivity, inclusivity, and sustainable development, which aims to foster economic growth and enhance global trade. So I would ask we all to join in and continue to strive for a peaceful and fair multipolar world, advancing economies through cooperation and mutual respect. Thank you.
And that's all the time we have for panel 1. Please may I pass the floor. Thank all for joining, panelists and friends. Please may I now pass the floor back to our MC.
Yeah, thank you very much. Thank you very much for the insightful discussion. I'm sure we all have useful takeaways from the session. We'll now have a short break before commencing the discussion on session 2, and I'll see you all at 11:30. Thank you.